This time on Introductory Politics, we move into the constitutional amendments. The original U.S. Constitution, Articles 1 through 7 of that document, were the ones that was the text that was originally ratified and in 1788, and ultimately, however, was not quite the end of the story. There were a number of folks who were dissatisfied with the structure and the power that was given to the federal government, but in exchange for ratification of the document, agreed that maybe we should at least provide some guarantees of personal liberty. And so a lot of what we see, of course, if you know anything about this time period in history, we're talking about the Bill of Rights, the first 10 amendments that were added to the US Constitution immediately after the Constitution took effect, and ultimately a subsequent number of amendments that were adopted after that. When it comes to these amendments, we're going to walk through all of them. We're going to talk briefly about all of them, some of them a little bit more, but at least highlight the very basic elements of each of these constitutional amendments. The First Amendment covers our what we consider generally our five fundamental freedoms, the five major civil liberties that are included in the Bill of Rights, which include our religious protections. This is the free exercise clause and the establishment clause of the First Amendment, our speech rights, press rights, assembly rights, and petition rights. The Second Amendment contains what we classically call the right to bear arms. This is our essentially basic gun rights amendment, which essentially says that well. I should put it this way, that historically was considered to be making reference to state level militias, not necessarily the individual right to bear arms, but that ends up changing in the early 21st century and has since expanded to allow for greater levels of personal, say, right to gun ownership. The Third Amendment. The Third Amendment, essentially dealing with the quartering of soldiers, limits the federal government's ability to use someone's private home as essentially lodging, like as a hotel for soldiers. And so when it comes to that, this is something that had been done historically by Britain, but this freedom was, even though not used in the United States since the development of this Constitution, does essentially guarantee that that kind of thing won't happen. Never been used in the United States, never been really challenged in front of the US Supreme Court. And so is one that is there, helpful protection, but is not one that is really of any sort of significance, at least immediate significance today. The Fourth Amendment. The Fourth Amendment does contain search and seizure protections. The Fourth Amendment is an extremely wide reaching amendment, far reaching amendment, in that it deals with essentially how the government, and largely when we're talking about search and seizure protections, we're generally talking about the police. And when it comes to when they are allowed to when they are allowed to search you, for how long they're allowed to stop you, seize you, that sort of stuff. There are lots of different kind of rights and liberties that are protected here. Some of these that we will talk about include things like the exclusionary rule, warrantless searches, probable cause, exigent circumstances, and lots of different kind of related elements of the Fourth Amendment. The Fifth Amendment, likewise, is going to be a very large amendment, and far-reaching amendment in terms of different kinds of rights and protections that are found there. For example, there are elements that are found in the Fifth Amendment related to your double jeopardy protections, your protections against self-incrimination. For example, like the common phrase of pleading the fifth is your protection against self-incrimination, and various due process rights. Due process rights are going to be a major deal when it comes to the Fifth Amendment. Understanding what due process is, the two main different kinds of due process, and how those are ultimately protected by the Fifth and later 14th Amendments. The last thing that we will talk about when it comes to the Fifth Amendment has to do with the takings clause of the Fifth Amendment, which deals ultimately with the power of eminent domain. The rest of the Bill of Rights, starting with the Sixth Amendment, we have various rights related essentially to the criminal justice process. Well, not necessarily just criminal justice process, but the justice process in general. The Sixth Amendment, related to criminal trials, does include rights and protections such as the right to a trial by jury, the right to a public trial, and the right to a speedy trial. The Seventh Amendment is going to not talk about criminal cases, but rather talk about jury cases, or sorry, rather talk about civil cases, and in particular, how you have the right to a jury in certain civil cases. And in certain civil cases, I essentially mean basically all of them. When it comes to the Eighth Amendment and talking about rights related to punishment, the Eighth Amendment is discussing cruel and unusual punishment. When it comes to the Eighth Amendment says that there will not be any excessive fines, bail, or punishment. Now, when it comes to excessive bail and excessive fines, this is fairly straightforward. And again, I assume that you have some level of kind of logical familiarity with this. If you were to say be arrested for stealing, say maybe a really nice shirt or sweater from a clothing store, they are not going to throw you in jail for the rest of your life, right? That would be an excessive punishment. Excessive fines, for example, if you were caught speeding and you were going 10 miles an hour over the speed limit, you were, say, maybe doing 70 in a 60, then you're not going to be charged, you're not going to be written a speeding ticket for $150,000. That would be an excessive fine. And so these are the basic kind of core elements of the Eighth Amendment when it comes to cruel and unusual punishment. However, one of the more challenging parts of the Eighth Amendment when it deals with cruel and unusual punishment has to do with the death penalty. The death penalty is often challenged in the courts, namely under the Eighth Amendment, and having to do with kind of whether or not the death penalty is essentially an excessive punishment, whether or not it is cruel and unusual. Overall, when it comes to how the Supreme Court has adjudicated death penalty claims, they generally say that death penalty is not cruel and unusual punishment. It is not an excessive punishment, and so it is essentially allowed. There are, however, certain restrictions for that. For example, when it comes to minors, when it comes to those who have, say, cognitive disabilities, when it comes to offenses that don't involve homicide, there are certainly some limitations that the court has articulated should be present. But, say, overall, as a possible punishment, especially for, say, murder and other high levels of crime like that, the courts have consistently ruled that that is permissible. The Ninth Amendment. The Ninth Amendment I have listed here as implied rights, or what we could also call non enumerated rights. The basic idea of the Ninth Amendment is that there are certain rights, certain civil liberties that the writers of the Constitution, that the writers of the Bill of Rights were not able to essentially articulate at that point in time. So essentially, thinking with our 1780s lenses on, there are certain things that we might expect could happen in the future that we just don't know about, right? There are certain things, certain rights that we may want to preserve for the future without knowing right now what those are. That's what the Ninth Amendment does. It means that there are certain rights that are enumerated in, say, the Constitution, earlier in the Bill of Rights, for example, but that those are not the only rights that people have, that there are other rights that we should have, and that essentially courts have the ability to decide what those rights are. When it comes to the Ninth Amendment, there are very few cases that deal substantively with the Ninth Amendment. The biggest one, at least maybe one of the original biggest ones, is Griswold versus Connecticut. Griswold versus Connecticut is the one that establishes the right to privacy and has been cited multiple times in a variety of different types of cases over the course of time since Griswold was adjudicated in 1965. The Tenth Amendment. The Tenth Amendment provides for rights that are kind of reserved for, sorry, not rights, powers that are reserved for the states. When it comes to the 10th Amendment, we call it the Reservation Clause because it essentially says that it says that any power that is not specifically given to, say, the federal government, that those are reserved to the states or respectively to the people. And so essentially, this creates our division of power, creates our federal system where we have certain powers that belong to the federal government, ones like the power to declare war. And then there are certain other powers not mentioned, say, for example, in Article 1, that belongs to the states. We're ultimately going to call those state level police powers. We will define that later. But ultimately, that's the basic idea is that states have some degree of sovereignty relative to the federal government, and that it is not the federal government that has all of the power.